Thank you, Rebecca. Very interesting. We're continuing with the Telecom Act Part 2, 1996 Telecommunication Act, Section 202H. You'll have to teach us how to do the keystroke for the section symbol. And Media Ownership Rulemaking, 1996-2010. We have Christopher Terry, professor at University of Wisconsin-Milwaukee, presenting.
I wish I could be quite as optimistic as Rebecca about this stuff, but sadly, I cannot. But while I'm getting this working, my first radio memory that I thought I would talk about was when I was on my college radio station the first night a tornado hit the building that I was actually broadcasting from, and the campus police drug me away in handcuffs, kicking and screaming. So that was the dawn of my radio career. But the one that I think is more relevant to this discussion was when I started in commercial radio. I was working for Hearst, and Hearst became another company, which became another company, became another company. The consolidation was so fast that in the span of 6 paychecks, I actually worked for 5 different companies. That's how quick it happened. But that's important because that's how I got interested in the topic of media ownership consolidation. This image here is a comment from the 2003 proceeding. There were many such public comments. I actually find this one quite compelling, though, in that it's written on a things to do note. There were email campaigns, there were lots of other things that happened, but there's all kinds of things in the docket that look like this. And what I'd like to talk about is sort of build on what Rebecca was talking about. I want to talk about how we got to where radio is today. And what I'm interested in is the FCC's application of structural regulation, specifically how they do it. And what they do is they control how broadcast licenses are allocated. And in 1996, the Telecommunications Act came in and changed an entire 70-some years of regulatory theory under the trustee model, adopting a new idea based on competition. And ever since then, things have fundamentally changed. Now, part of the requirement in 1996 is that the FCC take a look every couple of years at what the changes to the rules are doing to the media environment. The problem, of course, is that they started this process without any assessment in 96 of what the media situation looked like before the Telecommunications Act was implemented, which sort of left them hanging. And although they launched a proceeding in 2010, which they have to finish this year because the law mandates that they start a new one next year, we still don't have a solid answer as to what effect it has entirely in terms of real administrative law evidence. Now, the FCC, like any administrative agency, is governed by the APA, and that lays out the procedures. The Administrative Procedure Act lays out the procedures that the agency has to use when they take evidence in as part of a rulemaking proceeding or part of an evaluation of an existing rule. And these proceedings have, in essentially every administrative agency, have long been open to public input, but as you might imagine, it is the people who are regulated that have dominated this process essentially since the dawn of the administrative process. And compounding that problem now is attempts to sort of modify how agencies have to treat the evidence that comes in. The standard is under Daubert, which is a judicial rule on evidence that comes into a proceeding, and there's been a lot of effort to move that in, which already complicates a pretty complicated proceeding at the beginning. But to sum it up, to make it very simple and not bore you about administrative law, about which I could talk about for hours on end, this is pretty much how it works. There's a weight of evidence test. The agency wants to do something. They have to take the evidence that they have in the record, and then they have to have the evidence that supports the decision outweigh the evidence which doesn't support the decision. And that includes the external evidence which comes in from interested parties. And this is true of the EPA, the SEC, the FEC, whatever administrative agency you're talking about. They have to have evidence to support their decisions. But when it comes to media ownership, as Rebecca rightly points out, and as probably everyone in this room recognizes, the changes implemented by the 1996 Telecommunications Act had a significant effect on the environment for not only radio, but television and video programming, etc. And the debate over those policies has some significant social and economic aspects. I mean, I don't want to spend a ton of time talking about it. Everybody in this room fully understands that. But what doesn't get talked a lot about in academic circles, or at least not enough in my opinion, is how the FCC has used evidence to support these policies. It's a battle that requires them to have evidence to continue to do what they do. But the problem is they haven't had that evidence, or at least not significant enough evidence to support it. So that battle is one that the agency is significantly losing, especially when its decisions come up on judicial review. Now, there's two important factors to the rest of my discussion. The first is the provision within the Telecommunications Act. It's a paragraph long, section 202H, which requires that the agency review the rules under the media ownership policy and do so on a periodic timetable. It was first 2 years, it was extended to 4 years later on. But what's different about this and makes it almost entirely unique in administrative law is that to even keep a rule on the books, the agency has to have evidence to support it as if it were a new rule. So they've got to go in and support rules that they already have in place, which the FCC doesn't do a very good job of doing. And you don't have to look any further than the remands, pretty brutal remands, the agency has taken from the Third Circuit. Third Circuit's got no love for the FCC and never has had any, but the Prometheus cases, one in 2004 and again in 2010, pretty significant beatdowns of the FCC's approach to policy. But at the core of both of those decisions is a key idea. There is no evidence to support what the FCC has done essentially since 1996. And what have they done since 96? They've taken a structural policy called outlet diversity. Outlet diversity is a numeric limit on the number of licenses. As Rebecca pointed out, it eliminated the national limit for radio, putting in a market-specific limit where you can have up to 8 stations in a single market. Television works a little different. It's based on the percentage of stations that approach an audience size. But the fundamental premise of this policy is that if you consolidate stations, you create 2 types of diversity. And diversity is the end goal. Create a diversity in the competition between the stations. But the stations that are now co-owned compete with each other and diversify their program. Well, that's good theory. Sadly, it doesn't work out quite that way. Now, the structural limit, the outlet diversity policy, exists specifically by the FCC's own definition to create viewpoint diversity. More specifically, to act as a proxy for the measurement of viewpoint diversity. And it's pretty complicated. You have one owner, you get one viewpoint. 2 owners, you get 2 viewpoints, and so on. The problem, of course, is that the goal is as much viewpoint diversity as possible, and ever since 1996, and even arguably before that, the FCC's done everything it can to reduce the number of owners, which would seem to be an illogical policy application, because it frankly is. Now, my interest in this was to assess if there was any evidence that supported the fundamental policy. Does viewpoint diversity, do ownership diversity have a measurable relationship? And if so, how did they use the rationale of that relationship to assess the evidence they were using when looking at mergers? And what I did is I looked at 1,039 individual dockets encompassing radio mergers between 1996 and 2010. Okay? Now, there's a lot of studies out there who've done similar things on the docket evidence. Most notably, my very good friend Jonathan Obar's study, which looked at media, the comments in the record. But they've all sampled the material that's in there. I skipped the middleman. I looked at every single docket, every single page, and every single little bit of evidence I could find. I spent 11 months doing that. Now, what I found was that there is only one study that directly addresses this in the dockets at the FCC. It's a study from 2000 done by the person who oversaw my master's thesis, David Pritchard, who's looking at newspaper broadcast cross-ownership. Okay? That's the only one that directly addresses, directly measures the relationship between viewpoint diversity and ownership diversity. Okay? And while there's an unbelievable amount of evidence based on simple economic formulas, there's not much else. Right? There's no other supporting evidence in there, except for the comments from the public who speak very specifically to the questions the FCC asked about the ownership effects on the content. And I found quite a few of these, more than 1 million as a matter of fact. Now, I didn't read all of the public comments because the FCC was bundling them in blocks of 500, dating them and putting a rubber band around it and sticking them in the docket. But 500 similar comments in blocks essentially put in there. Now, I didn't do the assessment. One other assessment of these comments says that 99.89% of them were opposed to further increases in media ownership limits. That is public comments that come into the record. More than 1 million public comments came in the record before the 2003 decision came out. There's been almost that many again since then. And every assessment of those says that the public doesn't want this. Regardless of what the industry says, regardless of whatever else is being said, public simply doesn't want any more consolidation. And they don't want it based on the effect that they've seen on the media properties in their local market. But as I was going through the rationales that the FCC used, there's not one scrap of evidence anywhere in an FCC docket that suggests they paid any attention to this material. Thousands and thousands and thousands of pages of material just simply ignored, rubber banded, and stuffed into a docket. So that left me with a situation. How did they justify it? Well, between 1996 and 2005, the FCC had 3 different justifications for approving mergers. The first is the obvious one, economy of scale. Take 2 stations, you combine the operation, you can eliminate some staff, some redundant costs. Hundreds and hundreds of mergers, especially early on in the process, were justified simply on the idea that we can create a cost savings that will translate into better programming. No assessment of whether or not that actually worked that way, but that was used for a while. Then the economy of scale model wasn't quite as effective because the mergers were getting bigger and bigger and bigger as the process went along. So the FCC changed to a different metric. They began to support mergers by assessing the value of the advertising market and what the effect of the merger would be on the market. And they used this to ram through some of the bigger ones. AM/FM's merger by Clear Channel, and a couple of the other really big mergers were used under this. The problem was that they followed that track so long that they were actually ruling in cases where the advertising market would be left to the top 2 competitors. They would have 99.5% of the advertising market. So then they had to sit down and say, okay, we've broken another one. But then they did the most craven thing of all. In 2004, they returned to the numerical limits in the statutory delegation in the Telecommunications Act and said that they wouldn't make any other assessments. If it met the merger, met the guidelines for ownership that are in the Telecom Act, they would approve the merger. And it was only the Prometheus cases that stopped that process from going any further than it did. Some very good ones, some of my favorites, and there's hundreds of good ones. In Spokane, Washington, the entire merger of a group of stations is justified on the savings, couple $1,000 of office supplies, if you combine the 2 offices. 50 stations will move through that eventually. Cox has a very important precedent-setting case on the issue of economy of scale. They make a promise in their filing to hire additional women to increase the diversity. But their competitor in the market suggests, if you read a little further, it also says that Cox is going to make these benefits by eliminating tons of redundant staff. And of course, there's no assessment of whether or not Cox actually goes ahead and does any of those women, hires any of those women to make that. They just went ahead with it anyway, and the FCC approved it. Okay. My favorite, WMVP's promise to increase programming geared towards educating and informing the public on topics like drug use in sports, sportsmanship, and ethics in sports. A sports talk radio station actually argued that they would be able to do more of this if they were just allowed to consolidate with their chief competitor. And then one of the really damning ones actually happens in Ithaca, New York. Far into the process, 3 different citizen groups filed formal petitions with the FCC in opposition to a merger that would involve the Ithaca radio stations, which brought all 9 stations in town under one ownership because of how the market was laid out. So I got to the point and I said, okay, well, what we have here is a complete and absolute assessment problem. And the FCC's avoided every shred of evidence that goes against what they've been trying to do and just went with things that were convenient at the time. But as the process evolved, what I found was I actually believe that that was a deliberate attempt. People criticize the FCC for being inefficient, but I actually believe this was a deliberate attempt. And you don't have to look any further than 2 studies that mysteriously disappeared that the FCC lost in a drawer that were funded by taxpayers that suggested everything that they had tried to do since '96 was a complete and total sham. So that's what I found. And it's significant in terms of the regulatory environment because this is what was used to create the environment for radio today. A series of mergers based on irrational rationale and without any supporting evidence. And if we want to fix radio, if we want to get it back to its heyday, what Patty was talking about, this idea of public affairs, we're going to have to go in and break up the mistakes that we made. And it's just pretty much that simple. So appreciate your time. Thanks.